Yeah. Do you want to let the advocate just correct that? Yeah, of course.
Yes.
My Lord, if I may say so now, because I'm sure I'll forget, the advocate has indicated to me during recess that there was one matter in connection with the figures that she was offering to the court that she wishes to correct. So I think
would it be more convenient if you mentioned that now, Lord Advocate, rather than?
In fact, I thought the friend was going to refer to the total figure of devolution units seen in the case as far as 1,500, rather than which I mentioned of 1,000 plus there having been.
Yes.
The cumulative number is 1,500 in total.
Well, I think, as I said before, I think it would be very helpful if we could have it in writing.
Yes, I'll have a note.
And that will be up to date.
Certainly.
Yes, good. Thank you very much indeed.
now, my Lord, 5 minutes to deal with what I think is uncontentious material, but necessary information to enable my Lords to place Saldus in its proper place in the constellation of authorities. I don't think this is problematic or controversial. Indicated that I submit that this is not a case where one can simply apply it without further ado to Section 14. One needs to look at the judgment and derive from it those principles that can be read over to circumstances arising from Section 14 and thereafter determine whether or not Section 14 is compatible. It just reminds me, Lord, in that connection that the test that has usually been applied in this connection, and I'm not going to take my Lords to this, is found in the case of Allah, which is volume 3. Well, I did detect a collective wince when I mentioned.
I think we normally call it Ullah rather than Allah. It's the same case, I take it, is it?
I'm grateful to the Lord for that correction. For completeness, it's volume 3 tab 53, and what is articulated there is one is looking for clear and constant. The oddity here, of course, is I don't think we've got anything that's constant, but I think we could probably do something that arguably may be clear. That will be the issue for discussion. So if there's clear and constant authority, it should be followed. The second point, again, that I wish to remind your Lordships of is that, as we've already noted in the course of this morning's hearing, that Section 2 of the Human Rights Act enjoins the court to have regard to the Convention jurisprudence, and that is found, that section of the Human Rights Act is found at Volume 8, tab 223.
Take into account.
Indeed, yeah. It does strike me, my Lords, that really this is a little bit of a sideshow. The real question here is whether or not this court is satisfied that Article 6, as understood in Saldus, requires Section 14 to be read in a particular way. It seems rather beside the point to trouble oneself unnecessarily with whether or not there is clear and constant authority, because leaving that to one side, this court has got to, whether or not Strasbourg has decided a case in a particular way, it has got to decide today whether or not Section 14 can be read in a particular way or not compliant with Article 6. So that is my Lord asked what is the guts of this case. And I would respectfully submit that really is the issue at the heart of this case.
So when you say whether it can be read in a particular way, I'm not quite clear what you mean by that.
Yep.
Surely what you mean is whether it is compatible.
Yeah, I'm going to come on to submit that when one looks at section 14 in its context, that Article 6 does not require a lawyer to be present at the stage of detention. That is the road on which I'm travelling. And I say that Article 6 does not require that to be
Well,
the
then you
case.
don't have to read Section 14 in a particular way. You merely have to give effect to it, because that says you don't get it either.
Yep. That's it in a nutshell, my Lord. Yep.
So we don't really need to look at Section 2 of the Human Rights Act.
It is part of the apparatus, the framework that the court informs, enables the court to inform itself how it goes about the task in hand.
But recourse to Section 2 is only required where, if you give the words their natural and plain meaning, the possibility of incompatibility arises. If I've understood your submission correctly, you submit that there is no possibility of incompatibility.
Well,
if we have a proper understanding of Saldus.
That may overstate the position. What we're looking at in this case is what has been characterised as a structural incompatibility. Now, I'm going to try and tease out the difference between that as a proposition and the quite distinct proposition of actual incompatibility, showing a prejudice, showing a breach of Article 6, impacting on a given individual's rights. Now, while the two are not entirely distinct, I think we need to appreciate that. I think that is the way this case is being presented, is that one doesn't need particularly to look into the facts and circumstances of Mr. Cadder's case, or I would have thought any case for that matter. What really is being said is this court ought to see immediately on a reading of Section 14 a problem with it of almost a philosophical nature, quite apart from how it impacts upon a given individual, which is that there is a value enshrined in Article 6, as explained by the Convention jurisprudence. And Section 14 does not adequately secure that interest. So there is a distinction, an important distinction, I would respectfully submit, between showing in a given case that it actually harmed somebody not to have a solicitor. And that's not the line along which my learned friend moves.
I don't quite see why. I mean, he says, I didn't have a solicitor.
Yeah.
I mean, that's the...
And he adds to that, I made an incriminating statement.
Exactly.
I mean, you've got to have both of them.
Yes, of course.
And then you add to that, you find in subsection 7 that the questions are put without prejudice to any relevant rule of law as regards the admissibility and evidence of any answers given.
Yes.
So the question really is what's meant by that, and what does one read into the phrase any relevant rule of law?
Mm-hmm. I acknowledge that. So in looking at it in that way, the prejudice to which he points is the simple fact that the statement was taken and was relied upon in his trial without further ado. What I'm seeking to distinguish is the situation that was canvassed in discussion of what does one do when one can actually demonstrate that had he known, he would have taken a different course, or had he been better informed, a different approach would have been taken. I don't understand that there's any attempt to try and show, but for the failure, a different result would have ensued. Now, granted, it will be a very difficult thing to prove in many cases as to what would have happened but for the failure to inform of the right in question. But I simply draw attention to the fact that it does seem to me that in this case, the matter is being approached at quite an elevated level, which is leaving aside Mr. Cadder, leaving aside his circumstances. Here we have an intrinsic problem with the statutory scheme. And in that sense, to use the language of Mr. O'Neill, one has a structural problem.
Well, the court in Saldus and we've seen this phrase quite often, said that it wasn't for that court to speculate on the impact
Exactly.
which the possibility of having the assistance of a lawyer would have had on the outcome of the proceedings.
I think that puts the point exactly, is that what I think is being focused there is that very often times one cannot tell, one was unable to guess how things would have gone had the correct or appropriate legal assistance been provided to that individual. But it is enough simply to demonstrate that the advice was not available through the lawyer. That creates the problem.
Well, he says that's the breach.
Yeah, exactly. So I'm not quite sure how I got on to discussing that point, but I had one last matter I wished to... I think it may be, my lord. The last point I want to make in connection with the question of how the court approaches the task in hand is that my lords, I detect, are familiar with Horncastle.
Familiar with what?
Horncastle.
Oh,
I found reading that case interesting, not so much for the details of the reasoning, but what I detected was the collective sense of affront, that Section 116 of the Criminal Justice Act 2003, which represented the fruit of years of careful considerations to how best to handle hearsay evidence, given the fact that on the one hand it might be highly probative of guilt, and yet on the other hand, technically, was a breach of the principle that one must not convict somebody on the basis of hearsay. And Section 116, as the court sought to demonstrate at length and in great detail, demonstrated how English law had sought to secure the interests of fairness to the accused, and yet balanced that up against the need in appropriate circumstances to prove guilt. Now, Horncastle is entirely irrelevant to this case before the court today, save in this respect that it does show what can happen when the Strasbourg court looks at a problem and perhaps does not fully appreciate or understand how actually the system operates in practice. Because I think what I derive from Horncastle is that the Strasbourg court was not as well versed as it might have been as to how in practice those two competing interests weigh up against one another. Now, that is not a critical submission for this case. It's simply a reminder of the value and the importance in looking at any given provision in trying to determine whether or not it is compliant with the convention, being aware that sometimes it is necessary for the court to look at the detail of the matter and to be fully informed as to how in practice it works before an informed judgment can be made about it. So that is the window dressing out of the way. I now turn to the main issue in dispute. Now, I think it is helpful to actually look at Saldo's and look at it carefully. In my respectful submission, the heart of Saldo's is found in paragraph 54 and 55. And it is useful in my submission to look at the way the court expressed itself. So this is Saldo's is found at volume 6, and my numbering is page 141, but I believe it may be 142.
Tab 142, yeah.
Having read through paragraphs 50, 51 and 52, what, as one typically gets in the way that Strasbourg writes their judgments, is that these are, in a kind of loose way, linked together a whole series of propositions that can be vouched from the prior jurisprudence of the Strasbourg court, none of which is controversial. It does seem to me that when one gets to paragraph 54, that is the point at which...
What do you take from 52, just so as I know? It's not part of the heart here. What is it? Is it all right? How do you interpret that, Mr. Summers?
Well, paragraph 52 in my submission, what the opening part there, national laws may attach consequences to the attitude of an accused, has got to do with, I would have thought, although it's not spelt out, the rule about an adverse inference being drawn from silence, which is, I take it that is what...
Well, maybe not. I mean, maybe what he said. I mean, it's a bit part of it.
It's quite general, isn't it?
It is a very general statement, yeah.
Benefit from the assistance of a lawyer.
And the words national laws at the beginning indicate that it's looking at the entirety of the Council of Europe area, doesn't it? And it's not selecting out the Turkish system as one.
I think there is a measure of force in a point that was made this morning, which is the Council. They will not have been concentrating so narrowly in Turkey, I would have thought, as to exclude any awareness of other legal systems. That would be folly to suggest that. But I take leave to doubt whether or not they had in mind specifically the curiosity that is the detention mechanism found in section 14 of the Criminal Procedure Scotland Act. There are unusual features of section 14 that I would suggest would not have been at the forefront of the Strasbourg Court's mind when expressing themselves as they did here. Now, as a generality, I accept it is true that in such circumstances, Article 6 will normally require that the accused be allowed to benefit from the assistance of a lawyer already at the initial stages of police interrogation. But where I am travelling to in this submission is, after we have looked, as I hope to do in a moment, at paragraphs 54 and 55, is where does that requirement that there be a lawyer present stop? It was a discussion that briefly ignited in an exchange with Lord Mance this morning when the issue was raised, well, how far back down the line do we carry this need to have a lawyer? And rather than taking out of order, I want to address that specific issue just in a moment or two. At this stage, what I want to do is look at the reasoning in paragraph 54 through into 55. Now, how paragraph 54 opens up is this. In this respect, the court underlines the importance of the investigation stage for the preparation of the criminal proceedings, as the evidence obtained during this stage determines the framework in which the offence charged will be considered at the trial. Now, although no quotation marks are employed here, in fact, this is a straight lift from the case that is footnoted there, Kahn against Austria, and I think it is necessary to have a look at that case.
Yes.
It is, my Lord, bundle for number 83.
I think it uses the expression, the framework of the proceeding.
Exactly.
It certainly would be helpful to me to have your submission as to what that means.
No, that is why I've drawn it to my Lord's attention, because it is necessary to see this is not the language of the court in Saldus. They're borrowing from Kahn.
We've gone bundle 4. Where did you say we've gone to?
It is bundle 4
83.
at 83.
Yes, thank you.
I don't need to read much of Kahn, save to notice what kind of case it is. It's, first of all, a commission decision. You see that. And breaking into it in the the fourth line, what we find there is, in August 1980, the applicant, his brother, Reza.
So which paragraph are you at?
It's page 421 of the report, and it's the opening paragraph,
Yes, thank you.
it's 4 lines in under
Yes.
the bold type heading.
Yes.
In August 1980, the applicant, his brother Reza, and 2 Austrian citizens were arrested under suspicion of being involved in a crime of arson, Brandstiftung. The applicant's brother had confessed to setting fire to a restaurant which was managed by the applicant. The applicant was kept in detention on remand until November 81, when he was released on bail. In the beginning of September 80, the applicant chose Mr. Zita as his defence counsel. In the same month, he was visited by his counsel and by an assistant of counsel and was allowed to converse with them only in the presence of an officer of the court. Now, that last little phrase there, that is the issue in this case. As is explained, the following paragraph, 43 and letter A. The principal points at issue under the Convention are as follows: whether the fact that during the first months of his detention on remand, the applicant was not allowed to communicate in private with his chosen defence counsel violated his rights of defence under Article 6, and in particular his rights under Article 6.3b to have adequate facilities for the preparation of his defence, and under Article 6.3c to defend himself through legal assistance of his own choosing. So, very modest proposition that I derive from this, which is this: that opening sentence has got nothing to do at all with the sort of case we are here concerned with. The quotation that Lord Kerr, I think, who'd evidently read the case correctly, notes is found in paragraph 50, which is page 423. In the present case, restrictions were imposed on the applicant's contacts with his chosen defence counsel during a considerable period at the initial phase of the preliminary investigations. The Commission considers, having regard to the particular facts of this case, the guarantees resulting from Article 6.3b and c are in principle applicable to this situation. In the Austrian legal system, the investigation proceedings are of great importance for the preparation of the trial because they determine the framework in which the offence charged will be considered at the trial. Now, I'm not a linguist and a scholar, but I think all this means, my lords, is that if preliminary investigative work takes place, that, no surprise, that investigative work will determine the sorts of charge you face thereafter. I don't think, and I'm certainly open to correction, I don't think it means anything more than that. It's the curious phrase, the framework, suggests to me perhaps how the charges are phrased, or if there are cumulative charges, how they're set out one in relation to the other. But that is what Khan is authority for, and that is what underlies the opening sentence of paragraph 54. Commission case, arson, and a problem over the lawyer who had come to visit him not being allowed to conduct his consultation effectively in private. There was an official sitting and listening.
So it inhibited the preparation of the defence.
That's it.
Really?
Yeah, that's the point. Yeah. Now, I respectfully submit that the interesting thing about this paragraph is that one reads on down to the next part of it that is footnoted is towards the foot of the paragraph. The Lords will see that there's a footnote 23, and that precedes a sentence that reads, this right, that's the right of an accused not to incriminate himself, indeed presupposes that the prosecution in a criminal case seek to prove their case against the accused without resort to evidence obtained through methods of coercion or oppression in defiance of the will of the accused. So, just to take things in little parts, we then require to look at this case, which is the Jallow case, and that is found at Bundle 5, 114. all we need to do with this case, just to apprise ourselves of its nature, is just read the head note on the first page, which is page 667. The applicant was suspected of involvement in drug dealing. He was observed taking a tiny plastic bag out of his mouth and giving it to another individual in exchange for money. Upon his arrest, he swallowed the remaining bags. The public prosecutor ordered that an emetic be administered in order to provoke the regurgitation of the bag. The applicant was taken to hospital. He refused to take the medication and had to be immobilised by police officers while the medication was forcibly administered. As a result, the applicant regurgitated one bag of cocaine. At trial, the applicant disputed the admissibility of the evidence, arguing that the forced administration of toxic substances was prohibited under domestic law and in any event was unnecessary and disproportionate. The argument was rejected and the applicant convicted of drug trafficking. He was given a suspended sentence and he complained of inter alia violation of Article 6. The conclusion of the court in that connection is found on the following page at paragraph 3. And what, in summary, is said there is, whilst the admissibility of evidence was generally a matter for national courts, this was not necessarily the case when the evidence was recovered via a mechanism which was found to violate Article 3. The evidence had been obtained pursuant to domestic law, although in a manner which amounted to inhuman and degrading treatment. The evidence had been obtained in direct violation of one of the core rights guaranteed by the Convention. The evidence had been obtained in a manner which inflicted pain and suffering. The evidence obtained had been decisive in securing the applicant's conviction. The public interest in securing that conviction was not sufficient to warrant the use of the evidence at trial. The trial was therefore unfair. The proceedings also violated the presumption against self-incrimination. The evidence was obtained against the will of the applicant. The degree of force used was disproportionate, and the evidence had been obtained in violation of Article 3. The procedure in this case meant that the applicant was forced to incriminate himself. He was forced to surrender the evidence by means of a pathological reaction of his body, and there was insufficient public interest to justify such a move. The applicant was unable to understand the extent of the procedure, and there was no examination of his physical aptitude to withstand it. Further, the evidence was decisive in his conviction. Now, interesting case in its facts, but it's necessary to understand, this is the point I'm moving to, is that actually when you begin to deconstruct Saldus, and in particular this paragraph, what one finds is the section between footnote, the opening proposition in footnote 22, and the proposition found here under reference to footnote 23. It's that bit in the middle that represents the reasoning of the court. And I make nothing of the fact that there's no citation of authority for it. I just simply need to make it clear to the court that, in my respectful submission, this three-sentence section of that paragraph is worthy of careful consideration. Now, I want to break it down.
The three sentences at the same time and following, is that right?
Yeah, starting off with at the same time. So if we can break it down into its component parts. What one has is the first stage of reasoning, which states, at the same time, an accused often finds himself in a particularly vulnerable position at that stage of the proceeding. So the point is being made that at the investigative stage, you're vulnerable. Well, quite so. The next stage in the reasoning is this, the effect of which is amplified by the fact that legislation on criminal procedure tends to become increasingly complex, notably with respect to the rules governing the gathering and use of evidence. Now, I think what the court is driving at here is that you have an individual who, by virtue of the fact that he is at a stage of the process in which it is said he is vulnerable, The particular vulnerability to which attention is being drawn is that vulnerability that arises because one is unable to appreciate what may be complicated pieces of statutory material. And I think they define what they have in mind, namely the rules governing the gathering and use of evidence. It's not, again, I'm not a linguist, so I don't know whether it's a poor translation or not, but it is a rather elliptically worded sentence, because what it says is the effect of which is amplified by the fact that the legislation on criminal procedure tends to become.
But it's quite clear, is it not, that the vulnerability is not confined to an inability to understand complex pieces of legislation.
No, I'm not suggesting that.
The use of the word, the verb amplified, clearly indicates that the vulnerability is a wider reach than that.
No, my Lord, I'm not. I'm simply doing the task of pulling it apart into its component parts, and then eventually we'll put it back together again, and we'll see what one makes of it. So the proposition is he's vulnerable. Now that's no fault of the state.
Particularly vulnerable.
Pardon?
Particularly vulnerable.
Particularly vulnerable. I suppose the point is this, that as one moves on through the trial process and one's team assembles round one, and one settles down, aware of the fact that things perhaps have not gone as one might have wished, settling down to the proposition that serious consequences might well follow from what I have done. There is a change perhaps in the psychological approach, or the attitude that an individual has to the circumstance in which he finds himself. So all this is an observation in human nature. This is just a statement of the blindingly obvious, is that through no fault of the state or any other party, somebody at that stage, just in the nature of things, is, for reasons that aren't really fully explored, is going to be vulnerable.
To what?
Well, to a whole variety of things, I would suggest. This court, the reasoning of Saldus is moving towards the third sentence, to which, with your Lordship's permission, I'll now take him. What they then go on to say, in most cases, I know that there was a little bit of debate about in principle and as a rule, but I don't think we spotted this little phrase. And if we did, I didn't note it. But I do draw attention to it. In most cases, this particular vulnerability can only properly be compensated for by the assistance of a lawyer whose task it is, amongst other things, now I have the next little bit underlined, to help ensure respect of the right of an accused not to incriminate himself. Now, what is the court saying? Well, I would suggest there are a number of possibilities, but the one that springs immediately to mind, and it derives from that phrase, to help ensure respect. Or respect from whom? Well, I would respectfully submit that it's respect from the police into whose custody he has fallen. So what the court is driving at is that the lawyer is there to ensure that he's treated properly and to ensure that his rights are respected.
It's the right of the accused not to incriminate himself which is to be respected. Notably. They say, among other things, French says notably. So that's what they refer to.
Yeah.
It's explained also in a later sentence, so the one at the bottom of the page, early access to a lawyer as part of the procedural safeguards, etc., see whether the very essence of the privilege against self-incrimination has been extinguished. But the French says, actually the French is interesting because it's different, it says whether the procedure has or hasn't extinguished the very substance of the right not to contribute to his own incrimination, which I think makes the point my Lord was making, that it's treated as a positive right not to contribute to your own incrimination.
Yeah. I've no doubt that is is what is in view. What I draw attention to, however, is that it seems that what the court is saying here is that the lawyer is present to ensure that those in whose custody he now is respect his rights.
Is that not perhaps a rather narrow way of looking at it? Because he's in the custody of the police, but he's really in the custody of the state. The state will have access to all of the material that's generated as a result of their agents, the police, posing questions to him. So respect surely goes further than simply ensuring that the police comply with, for instance, their statutory obligations in relation to caution.
Well, my lord is entirely right that there are a number of readings. I mean, it's just in the nature of things that as I approach it with a particular mindset, that I see it in a particular way. But it's entirely possible that one could even read it broader than my lord suggests. It may be that all this is saying on a very liberal reading is to ensure that from whatever source or angle or person a risk may arise, he's there to stand between his client and the foe, whoever and whatever that foe may be. That would be the very broad reading. But I would respectfully submit that in its context, what the natural reading is that he's there to ensure that the police officers don't overstep the mark.
Sorry, the police?
The police officers don't overstep the mark. He's there to ensure that they respect the right of the accused not to incriminate themselves so that they don't put illegitimate pressure on him, so that they don't treat him in a way that's unacceptable.
One can't help noticing the last sentence of paragraph 55, which talks about the possible assistance of a lawyer, and that suggests that the lawyer is there to assist the person who's being detained. He's not there just to make sure that the police refrain from whatever it is, beating the man up or whatever, but he's there as a lawyer to assist, and that suggests giving legal advice, and it's tied to the idea of not incriminating himself and so on.
Well, there we have it. That's another. I mean, it is possible, consistent with how I have read the sentence, to square it up with the sentence that the Lord was pointed to in paragraph 55, which is he is assisting. Of course he's assisting.
I mean, one's not got to read too narrowly, Mr. Summers, because we think of it in terms of police and so on, but there are all these other continental systems where you have magistrates and so on who are, and those things who are doing the investigations and so on. And that's, I mean, it's phrased in this sort of general way because it may apply to all these kinds of systems.
Trying to think about how does one get to these three sentences? What is the source? What's the inspiration? What are they drawing on for these articulations of principle, given that they're not footnoting any case law? And one of the characteristics of the judgment up to this point, it is quite a loose stitching together of principles articulated in a whole variety of. It seems like the house style of the European Court is to write judgments in that way. But here, and the point I make here, is that one has a section of the judgment where that stops. And it does seem that this is the heart of Saldus. This is the court articulating what has been called the extension or the development or whatever it may be of its jurisprudence. Now, how does one approach that? Well, I respectfully submit that there is a narrow, a cautious and a conservative reading of it, which is that what really the court has in mind to do is acknowledge what we all know to be true, which is that through no fault of the state, or what was the result of any act of any police officer, or whatever it may be, individuals in that position are vulnerable, period.
Well, I'm sure you'd accept that mustn't be taken too narrowly out of context.
No, indeed.
And just referring to the sentence that my Lord mentioned earlier, early access to a lawyer as part of procedural safeguards, to which the court will have particular regard, and examining whether procedure has extinguished the very essence of the privilege against self. What do you think the court meant by the very essence of the privilege against self-incrimination?
Well, all I can do is tell you what I think, which is perhaps a lot different from what may be. What I think they meant was that they were acting so as to prevent the very thing that has been a theme throughout the Lord Advocate's address, which is the background issue of coercive or intimidatory methods being employed so as to coax from the applicant information that he would not otherwise venture.
Why do you have a caution at all then? If that's the only protection that is relevant, why do you have a caution at all? Why do you remind people of their right to silence? Wouldn't an advocate have a role in giving advice as to the significance of giving up your right of silence? Isn't that part of the caution? Is part of the respect for the right not to incriminate yourself?
Yeah. I mean, it does seem to me that it's extraordinarily difficult to extract from Saldus and all the other cases universal principles because they are so fact dependent.
But your submissions are actually contrary to the way the court, admittedly chambers of the court, have interpreted Saldus.
I freely accept that. I should make that abundantly clear.
They're absolutely contrary to both, what was it called, the Russian one, Panovitz, I think it was Russian, wherever it was, and Dayanan in Turkey, where Dayanan in Turkey, the chap didn't even speak.
No,
and they held...
Yeah.
It's quite interesting in Dayanan in Turkey that the translation of it's tab 90. Volume? Sorry, it's tab 87 in volume 4. If you look at paragraph 32, which is the core paragraph.
Catch up. What tab is this? 87.
Yeah.
Which paragraph?
Paragraph 32 is really the core one, and remember this is a case where he exercises his right of silence, but nonetheless they say there's a breach. And they refer to full gamut, the full range of services provided by the lawyer, and then they specified.
Yeah.
It's also quite interesting that they talk about the right at the top of the page, the right of an accused person to have access to a lawyer. And that's a translation of the French pouvoir bénéficier de l'assistance d'un avocat. So, I mean, it may be that assistance is actually the wrong word, because here they're translating it into English as access.
Whose translation is this?
Well, I don't know, this is one which is produced by appellant, isn't it?
Yes.
But I mean,
No.
strictly, I mean, assister is to be present at, not to assist. Aider is to assist.
Lord, I didn't do very well at French at the school, so I'm not professing any ability at all to assist the court.
I mean, it's a different translation of the same phrase, which in the official French translation in Saldus has been translated as assistance like the French, but it may not be right.
I mean, I have to face up to the fact that you've got case law interpreting Saldus, doing the very task we're doing, just interpret Saldus, and they're interpreting it. Now, I face up to the fact that amongst that interpretive body of case law, there is a case in which the individual, as well as said nothing. So one is then back to the point that I made at the outset, which is these are bare rights that are being protected here. The right not to be questioned without the presence of the lawyers. and I'm going to come on to make some submissions, whether that is consistent with convention jurisprudence in a moment, is it there, is 6.1 there to protect bare rights, or is it not? But equally, this motley selection of cases, that in the very short period of time that is elapsed since Saldus, there is a case that says that the reach of Saldus is not so long that it stretches back to the first encounter with police. My Lord will remember the case involving the gasoline. I think that was the Russian case. And one is going on ahead of himself, but one is then there seeing that, one is appreciating that the court itself understands there are limits to the ambit of Saldus, how far back through the process, through the continuum of cases where an individual commits a crime. He confronts the law enforcement authority in the form of a police. They ask him questions.
But some of the problems that seem to be addressed in Dynon, anyway, don't arise in the case that we're considering. I mean, after the 6 hours, the detainee is released, and under the Scottish system, there's simply no problem about access to a lawyer after that event, is there? I mean, what's being complained of here, and I'm looking at the French, is the inability to obtain the vast gum it talks about of interventions which are necessary to give advice and so on. And all of that is available here except for the 6-hour period and the initial questioning during that period. And I'm not quite sure where we're going to. You seem to be saying two things. One is that the thrust of paragraph 54 is really directed towards coercion, coercive measures to extract information, and therefore the presence of the lawyer, you say, is there to, as you put it, to ensure that the police don't overstep the mark.
Respect, yeah.
But are you then saying that there isn't anything here that actually points directly to the necessity for legal advice to underwrite the administration of a caution?
That is exactly what I'm saying.
I mean, the caution is administered, that's part of the system. You're saying it doesn't appear to be discussing that, or the suggestion that that in itself is not a sufficient protection.
It may be wrong of you to say so, but I had the sense at times that a number of quite discrete steps in the legal process were simply being conflated. Because one has a policeman saying to an individual, these are your rights, you do not need to say anything. Now, I would submit that warning doesn't fall within the second sentence in the little section we've been looking at, which is a quite distinct idea. Because what if there are complex or detailed or specialist rules arising from the statutory apparatus and the law of evidence that need to be explained? A lawyer's the man to do that. I do not submit that a lawyer really is in any better position to improve upon the warning that is given to an accused by a policeman.
Well, experience of the judicial examination process suggests the contrary, because every time a question is put, the individual looks to his solicitor, who shakes his head, and says, well, I'm not going to say anything, thank you very much.
But this is my point, is I wonder respectfully, Lord, whether that's conflating a separate point with the issue in hand, because what one is then moving to is not so much the warning being given, but the explanation about what it will mean to an individual. That's that's the next step along the line. So if you say to somebody, look, you have a right to remain silent. If you do say anything, it may be used against you in evidence. Now, I would respectfully submit there is nothing complicated about that. The next step along the line, there may be a number of paths along which this gentleman may travel thereafter, but one would imagine that one distinct possibility, at least, is that a lawyer with the benefit of many years' experience in Glasgow Sheriff Court or whatever other court one cares to mention in Scotland, he would say, look, there's a simple solution to this. My experience tells you, say nothing. Say absolutely nothing, because I'm telling you that's the advice I'm giving you. But that is a distinct step from the explanation of the right. That's advice being given. Now, I think my Lord Brown mentioned in the course of yesterday the possibility that a lawyer, unless he's got an articulate or intelligent client, will probably not sit down, put his arm around the shoulder of the client and say, look, give me half an hour of your time and I'll explain how this fraud case may go, so that that client may then interact with his lawyer in an effective way. Well, there are a whole variety of possibilities. What really one has here is just the fruit of years of experience, saying, you have a right. Here is my advice about how to exercise it. Say nothing. And that's a distinct
Mr. Sutherland, you've got a right not to make self-incriminating statements.
Yeah.
And this particular appellant had that right. Do you say he waived it?
Well, I don't think I could go that far, because the European...
Don't you have to go that far?
Well, when I replied to Lord Roger this morning in connection with Maclean, and my Lord asked me, did I take my stand on Maclean, and I said, no, I don't. But I was not suggesting by that everything in Maclean is wrong. And one of the points that Lord Justice General Hamilton makes in Maclean is that while it may not amount to a waiver, because the European jurisprudence and how clear, precise and unambiguous it requires to get to the level of waiver, it doesn't follow from that if it falls beneath full legal waiver, that it's not an important factor to weigh.
What is it then? If it's not waiver, what is it? So
well,
nondescript, what is it?
Yeah, well, my Lord borrowed from the language of medical negligence, I think, in the course of the hearing 2 days ago, and spoke about the difference between informed and uninformed consent. And whether or not it has got to do with how well informed I am. And that may be of a matter that admits of degree. But waiver is a very, very powerful barrier to...
Your submission is very odd, isn't it? I mean, you can have countries where there's a systematically inappropriate system, and in those countries you can only rectify the position if there's a full and informed waiver, which involves real understanding as to the significance of what you're doing. But in other countries, you can have a system which nonetheless allows you to incriminate yourself without being fully informed in the same way. Seems...
I don't pretend that this is an area of law that's been analysed in a comprehensive way over the years. One does get the distinct sense that in this case, what one is trying to do is to weigh up the effects of Saldus. I accept it's not in waiver territory, but it does respectfully appear to me that it is an important factor to weigh in the balance.
If we're going to weigh the effects of Saldus, could you just give me one sentence when you tell us what the effect of Saldus is in your submission?
Yeah, what I submit is that Saldus is authority for the proposition that the current regime, where after somebody...
proposition that?
When somebody is arrested...
Authority for proposition that? The present regime or something, did you say?
When someone is arrested.
When somebody is arrested and charged, that is compliant with Article 6.
Someone charged. So what happened?
But that the reach of Saldus does not extend back into Section 14 detention.
Can I be quite sure I got this? Could you put it out, say it again, please?
Regrettably, it wasn't a proposition I wrote down before I came to court, so I may not repeat it word for word, but my point is this, that What is clear is that there are a continuum of circumstances in which the police may question an individual and in which one may make incriminating statements. My submission is that it is important to know when in that ban the lawyer must be inserted as providing a protection. What I say is that if it is accepted that he doesn't need to be there from the outset, notwithstanding the fact that catastrophic statements, self-incriminatory statements may be made at the scene of the crime, in the sitting room, on the pavement, on the street, wherever the police come into contact.
And that you're envisaging remarks made without questions being put. Somebody is just put into a room.
I think the Lord Advocate, rather imaginatively, if I may respectfully so, picture a gentleman with his striped jersey and his swag bag. Now that to parody the reality of life, but what one has there is exactly the issue this case is confronting, which is...
If you see somebody with a swag bag and a striped jersey, you immediately have a reasonable suspicion that he's been stealing things. So you have to then use the section. I mean, that's the whole point. It's once you form a reasonable suspicion, then you must detain the person for question. You can't question him. You can, of course, if you go to a scene of an accident or something like that, you can say, "Oh, were you driving?" or something like that, and so on. And then, the moment you start to form a reasonable suspicion, that's when you've got to detain the person, and off you go. I mean, that's the rule. It's not that you can't ask any questions at all, but once your questions lead to a reasonable suspicion, then you have to go in under Section 14.
The analogy is a very poor one. So we just remove the striped jersey and the swag bag.
Well, we can do
because that is over-egging the illustration, because it's clear and apparent. I mean, I've never seen anybody in a striped jersey or with a swag. It's one of those sort of...
Well, people often make statements. I mean, the police officer says, "Do you want to go to the toilet?" And the chap says, "No, the only thing is I wish I hadn't done it."
Going to the toilet, we were learning in
Yes, I mean, you do get the most bizarre statements in criminal cases.
Yeah, it's a natural process.
But once he says that, then you've got to detain him.
But you can say, I think, Mr. Summers, if you look at the earlier part of Saldus, which you're asking us to overlook, there's a history given between paragraphs, I think it's 12 to 17. And this individual went through a whole process right up until and including the appearance before the investigating judge. And all the narrative is set out in the very last sentence of 17 says, the applicant then had the possibility of calling on a lawyer. Yeah. So, I mean, what they were faced with is a great progress of the case being built up against him, getting him to say things, first of all, at the initial stage, and then later, when the public prosecutor gets him before the investigating judge, he says more things, and all of that's without the assistance of the lawyer. And then you take us to the analysis of paragraph 54 and say, well, it's a sort of hodgepodge of bits and pieces of learning taken from various things, which are not actually like the kind of problem we have in sections 14 and 15. And they're brought together to deal with the problem that arose in that case. And should you really apply it to what's going on in sections 14 and 15?
Yeah,
that's really what it comes to.
That's what I'm saying, yeah. The difficulty is that, the Turkish system, it's a system that we're looking at here, is one that doesn't fit neatly or well with what we are acquainted with. As I understand it, what happened was that he was detained, I think, at the back of 10 o'clock. I think by the time he got to the prison, it was at 1 in the morning. And then thereafter, after being interrogated, he is taken before, I think it was a prosecutor. And then after the prosecutor, he's taken before the investigating judge. All of which are, alien ideas to a Scottish lawyer.
We saw some Scots case where the chap was taken from his bed at 4 o'clock or 4:30 in the morning and examined, didn't we? And that was held to be fine.
it wasn't so much getting out of bed early in the morning that's alien to a Scotsman. It's the idea of being in front of a prosecutor and then a judge and being interrogated. That's the part of the process that is unusual to the Scots lawyer's eyes. But
Mr. Summers, did I understand you were drawing, when you gave us that proposition, you were drawing the distinction between the detention stage and the stage of arrest. Is that right?
That's exactly
And you were
right.
saying that Saldu's, you were going to apply Saldu's only to the stage of arrest, at which point they win, because at that point you get a lawyer and anyway you can't be questioned.
What I'm doing unapologetically is a particular set of facts and circumstances, and I'm trying to weave it into the case law and wondering and suggesting to the court that where does one insert it along the line of possible methods.
One might get an insight from the first sentence of 55. You insert it as from the first interrogation of the suspect.
Well, my lord.
And Judge Bratzer picks up the phrase and questions whether it shouldn't start earlier. He says, does it really only arise at the moment of first interrogation? But you have to say, goodness me, it doesn't arise then, it arises much later, namely at the end of your Section 14 6-hour period.
Well, I actually thought what Judge Bratzer said assisted my argument, because what I think he's saying is that the majority judgment doesn't state the principle widely enough.
Yeah.
So, I think that sheds light, helpful light from the point of view of my argument, that actually, when one was trying to work out when it is the convention requires a lawyer to be inserted into the process.
Well, he was thinking, wasn't he, of a situation in which someone is picked up and left in a cell for 48 hours just to reflect on his situation before any interrogation starts, which indeed is a feature of some of the Turkish cases, isn't it?
That may well be what he had in mind.
Could I go back to the question of waiver? Because you rightly say that Strasbourg treats waiver as something quite solemn, requiring informed consent. Just thinking of possible changes that might be considered, suppose Section 14 were amended so that it gave a right of access to a solicitor and that the 6 hours, say, ran only from the time the solicitor arrived at the police station, something of that sort. What then if the suspect says, I do not want a solicitor, and he's not a 16-year-old boy, but he's age 25. He says, I have thought about it, I do not want a solicitor. What are the police going to do then? Are they going to say, are you sure? Are they going to read him 3 paragraphs of Saldo's? I mean, how would it work? Because this may be a practical problem that someone's going to have to think about.
Yes, I can see that, my lord. Yeah, I mean, how one. The chances of a Scottish policeman reading Saldo's is, I would have thought, extremely unlikely. Well, he might say to him, "Are you really, really sure, son?" In a sort of fatherly sort of way. But if he says, "I'm really sure,"
and that's a waiver, is it?
Provided that there is record. I would imagine if he's got any sense, he'll record it on an audio tape, and if he's got a lot of sense, you'll have the CCTV running as well. What he will get from him is a clear explanation of the rights that are at stake. And if there is a man of years and of sound mind, and he says that I've thought about it and I don't want a lawyer, I wonder whether in fact that is not enough to be a waiver.
The English process under the PACE code is immediately prior to the commencement of any interview at a police station or otherwise authorised place of detention. The interviewer should remind the suspect of their entitlement to free legal advice and that the interview can be delayed for legal advice to be obtained. It's the interviewer's responsibility to make sure all reminders are recorded in the interview record, which has to be shown. So, I mean, obviously recording would be an even more sensible course to take.
Yeah, I mean, the task I'm undertaking here is made more difficult by the Police and Criminal Evidence Act, because my lords are familiar with a sophisticated, nuanced statute that approaches this problem in a very particular way. But with respect, what actually we really have to do is, if we can, put the Police and Criminal Evidence Act to one side and concentrate on the issues, the principles of ECHR jurisprudence, and ask whether or not we may have a system that is not as good as the Police and Criminal Evidence Act. But the fact that it's not as good as doesn't mean it's non-compliant. And what I am submitting is that if one reads the case law, Saldus in particular, that it is possible to come to the conclusion that what one has in Section 14 is a circumstance where Scots law gives him his right to silence and does not attach any penalty to him if he exercises. My Lord Roger asked, how far do I go in support of Maclean? Well, what one finds in Maclean is a lengthy rehearsal of all the ways in which fairness is provided through the whole trial process. And actually, I would respect that there's only two of those issues really matter. And the two that really matter are the fact you can't draw an adverse inference and the fact you require corroboration. I think my Lord was asking which of the protections we offer meets the problem, which of them addresses the mischief. And I think the view may be, so, well, there may be none. Well, I would submit there are, and there are two. And the two protections that address the mischief are that no adverse inference will be drawn from your silence and corroboration is required.
Is the questioning that takes place during a period of detention, interrogation, as that expression has been used in the Saldus?
Lord, I didn't catch
it. Is the questioning that takes place during a period of detention, does that constitute interrogation, as that expression has been used in Saldus?
Well, I submit not, my Lord. I think read in context, there's a number of phrases, a number of different ways in which that process is described. I respectfully submit that what is in view in Saldus when we're told about interrogation is analogous to the circumstance that arises after when one is questioned after arrest and charge.
Which French or English word would they have used for the douce way in which people are questioned in Scotland?
I didn't pick up the start of my question.
Which word, English or French, would they have used in Strasbourg to describe the douce way in which the questioning goes on in Scotland? Instead of interrogation,
well, I have tried to find that word, my Lord, and I would call it an interview.
Well, that's what the Statement of Facts and Issues calls it. It's an interview, but it's no different, is it?
Yeah. But it may be all in the language. Again, as I read it, the word interrogation, to my ears and my eyes, it has the flavour of coercive questioning.
No.
We're told quite specifically it's got not to be coercive. I mean, that's part of the thing. It's what we're told in the thing.
I mean, in
Where's the word interview?
Strasbourg case, or surely a neutral term, meaning an interview.
If you're asked questions which are capable of eliciting an admission of guilt, for my part, I find it very difficult to see how that would not constitute interrogation in the way that expression has been used in Saldus and indeed other jurisprudence.
But my Lord has heard what I have to say about that. It would respectfully appear to me that one may well have that self-same process of interrogation at a point in an individual's contact with the state that lies outside the ambit of Saldus. And in that connection, I have in mind the Russian case where there was no suggestion of a prison cell. Or
Which one was that?
the one involving the gasoline.
Beginning with a Z. What's called?
Zychenko, yes, 616A, yeah.
My Lord, I don't intend to labour this point. I've made my position clear on that, and I would like your Lord's permission just to move on.
Well, I think you've got about 15 minutes to go before Mr. Shedd has his right of reply.
Well, I shall get a move on then.
Yep.
Now, just to draw the threads here, what I am saying is this. The case law does not support the proposition that a lawyer must be present every time a suspect is interviewed, and I submit that detention under Section 14 lies outside the scope of Salvi's section. I want to turn to a second point, which is this, is that actual prejudice must be shown. And I want for that proposition to turn to Murray, which is volume 5, page 126.
So what was the proposition, did you say?
Actual prejudice.
You have to have it.
Yeah.
Before what?
Before a breach of 6.1 can be, or the fair trial guarantee can be.
Is that different from 6.3?
Well,
Article 6 in general?
well, can I read from Murray, which what it shows is that.
Well, we might just read from Saldus and so on. I mean, you know, or you could read from Dianan, which paragraph 33, which says that in itself the restriction is a breach.
Yeah.
And then adds, even though, despite the fact that the person remains silent.
Yep.
So what's the prejudice? And then you get €1,000 for that.
But that is a point I sought to address just 15 minutes ago, which is that what I am submitting is that those cases overread Saldus in as much as, if one looks at Murray, as I hope to do in a minute, is that the simple proposition that one is not given a lawyer, but you can't show what prejudice that caused you, seems to me to be inconsistent with what Murray describes as the heart of the 6.1 guarantee.
But all they did in 33 of Diane, or whatever it's called, Dianan, was to add one clause at the end. And apart from that, they just reproduced the words of Saldus. They just reproduced them word for word.
Yes, I know.
So, I mean, can one say they misread it?
Well, that is the submission that what 6.1 guarantees is a fair trial. What got to show what was unfair about it. Now, if it is the case against me that the simple fact that you didn't have a lawyer there, even though one didn't utter a word, if that is the unfairness, then
that's a breach of Article 6.
Yeah.
And that gets you €1,000, but it doesn't necessarily, of course, in this case, they say because the man remained silent, it wouldn't have resulted in his trial. There was nothing went wrong with his trial from that point of view. So he got €1,000, nothing else. They didn't say anything else.
And that's remedy.
Yes, exactly. But it was a breach of Article 6.1, even though, or 6.3c and 6.1, even though it didn't actually render his trial unfair as a whole.
Yep. I see that very clearly. That is what those cases say. And what I, if my Lord will allow me to, is to submit that seems a little bit inconsistent with what the court has said in Murray, which is that one is not looking for the denial of a bare right with no obvious palpable prejudice.
Can you point to the paragraph in Murray where you say that emerges?
It's paragraph 59, 60, 62 and 63.
Yes.
59, did you say?
Yes.
5126. 5126.
Yeah.
Sorry, which tab is Murray?
It is 5/126, volume 5, tab 126.
So he was denied access to any legal advice for 48 hours.
That's right, Lord.
Yeah.
If I may read paragraph 59.
He's, because of the terrorism aspect, he's systematically denied representation, but he remains silent, and the point there is whether it's appropriate to draw the inference from that silence. Is that it?
Yeah.
Is that it?
If I may, take the law to page 64 in paragraph 59 and show how the court lays it out.
Paragraph 60 is the government's submissions, isn't it, I think?
It is,
Yeah.
Lord. Yeah.
It's tab 126.
Which page?
It's page 65.
Perhaps if we just read from paragraph 62. The court observes that it has not been disputed by the government that Article 6 applies even at the stage of the preliminary investigation into an offence by the police. In this respect, it recalls its finding in the Ambrosia against Switzerland judgment, especially paragraph 3 may be relevant before a case is sent for trial, and so far as the fairness of the trial is likely to be seriously prejudiced by initial failure to comply with its provisions. As it pointed out in that judgment, the manner in which Article 6.3c is to be applied during the preliminary investigation depends on special features of the proceedings involved and on the circumstances of the case. National laws may attach consequences to the attitude of an accused at the initial stages of police interrogation which are decisive for the prospect of the defence.
Surely what you want is the actual decision that 66
I
to 68 is
think-
Well,
Well,
66 is
yes.
helpful. 66 is quite important, isn't it?
Have I got a
Paragraph 66 is quite important.
Is it 66? I may have noted this. Yes.
Because it's making the point that there was a sort of double fix here. If you remain silent, then inferences can be drawn against you. If you say something, you may be irretrievably prejudicing your defence. And given, as it's put in the second paragraph, under such conditions, you should be given legal advice. And then the conclusion is the absence of legal advice it amounts to prejudice, and that's it.
Yes, my lord.
and your court doesn't speculate as to what would have happened, which way it would have gone.
Yeah.
So it's against your proposition, isn't it?
And that's picked up in Saldas precisely, at paragraph, I think, 58. The court does not speculate on the impact.
Yeah, certainly it's exactly the same phrase, and one
Yes, and it's
might
repeated
well
after
speculate that it's the same proposition that's used.
Yes. Well, that just underlines the point that Lord Roger was making, I think. Just underlines the point Lord Roger was making in itself.
It's pretty difficult to establish that proposition, that actual prejudice must be shown before there's a breach of 6.1. But, I mean, can you get anything from the proposition that actual prejudice must be shown before you can show there's a miscarriage, an unfair trial, miscarriage of justice, entitling you to have the conviction set aside?
Well, I don't enter upon that
McInnes the last
discussion.
word on that.
It's not really for me to get involved in that sort of question. That is a matter for the Lord Advocate.
Well, I wonder whether we've reached a position where Mr. Shedd should have his right of reply. Is there anything else you particularly like to add, Mr. Salmond?
No, my lord. I think that is sufficient for questions.
Thank you very much. Mr. Creedy? Thank you. Well, Mr. Shedd?
Yes, thank you, Lord. Lord, if I could return to the point Lord Roger raised earlier, just a practical matter, Lord, about the membership.
Could you switch on?
Yes. The Lord asked about the membership of the Thompson Committee. Sorry, Lord. I'll try and find a happy medium. Lords, there are copies available for your Lordship now of the membership of the committee, and I'll have those distributed if I could.
Thank you, Mr. Shedd.
Thanks. Lords, if I could mention just one practical matter as regards the question of commenting on an accused exercising some form of right of silence in Scotland, just so that your Lordships are clear on the matter, because it's been discussed in the context of judicial examination. There is a right for the prosecutor, the trial judge and counsel for the co-accused to comment in certain circumstances arising from judicial examination. Perhaps I could just say that to my Lords very briefly. It's to be found in section 36 of the Criminal Procedure Scotland Act 1995.
That's a judicial examination.
It is, Lord, and that's, my Lords may find, it's reproduced at volume 8, tab 205.
But a judge is not allowed to comment on silence during an interview.
No, Lord.
I mean, under the Old English law, a judge could do that, but it was very, very, very rare in the last, before the statute.
There's a limited recognition, Lord, in some of the case law that if, as it was sometimes put, I think, Lord, in the Scottish cases, the evidence called out for an explanation for the accused, then in limited circumstances the trial judge might comment with restraint on that aspect of the matter. It's not common in practice, I think it's fair to say.
Very uncommon, I think. Judges
At your peril as a judge, I reckon.
Exactly. That's exactly it. Exactly.
What was the position before the 1980 Act, do you know?
As I understand it, Lord, it was as I've just described to your Lordships. That's a strand in the common law of the case. And I think it goes back at least to a case in 1948, a case of reset. I'm afraid the name of the case escapes me for a moment, Lord, but I think that's the theme of the matter, which is that on occasion the evidence might call out for an explanation. But I think, as my Lord Roger points out, it's generally...
One has to remember there was no criminal appeal court in 1926, so what they got up to before that, heaven alone knows.
Yes, indeed.
Lords, I didn't wish to take up too much time, but just to put this in context from Lords, Lords will see it section 36, it's subsection 8 in particular, for the assistance of your Lordships. The Lords will see an accused may decline to answer a question under subsection 1 above, and where he is subsequently tried on the charge mentioned in that subsection or on any other charge arising out of the circumstances which gave rise to the charge so mentioned, his having so declined may be commented upon by the prosecutor, the judge presiding at the trial, or any co-accused, only where and insofar as the accused or any witness called on his behalf in evidence avers something which could have been stated appropriately in answer to that question. So, Lords, just to really clarify that, but in so doing, Lords, I don't, of course, seek to call into question the practical observations my Lord Roger made about experience of the use of judicial examination in practice and the intervention of a solicitor. Lord Roger also mentioned in discussion this morning the case of Chalmers and the observations of the court as to the sinister venue of a police station. Lords, if I could just mention briefly the case of Chalmers to your Lordships. It's volume 1, tab 7. Lords, perhaps I could draw my Lord's attention to the opinion delivered by Lord Justice General Cooper at page 78 of the report. Lords will see there just 3 or 4 lines from the top, his Lordship's observation to this effect: it's not the function of the police when investigating a crime to direct their endeavours to obtaining a confession from the suspect to be used as evidence against them at the trial. In some legal systems, the inquisitorial method of investigation is allowed in different degrees and subject to various safeguards, but by our law, self-incriminating statements when tendered in evidence at a criminal trial are always jealously examined from the standpoint of being assured as to their spontaneity. And if on a review of all the proved circumstances that test is not satisfied, evidence of such statements will usually be excluded altogether. The theory of our law is that at the stage of initial investigation, the police may question anyone with a view to acquiring information which may lead to the detection of the criminal, but that when the stage has been reached at which suspicion, or more than suspicion, has, in their view, centred upon some person as the likely perpetrator of the crime, further interrogation of that person becomes very dangerous, and if carried too far, e.g. to the point of extracting a confession, by what amounts to cross-examination, the evidence of that confession will almost certainly be excluded. Once the accused has been apprehended and charged, he has the statutory right to a private interview with a solicitor and to be brought before a magistrate with all convenient speed, so he may, if so advised, emit a declaration in the presence of his solicitor under conditions which safeguard him against prejudice. The practice of omitting declarations has very largely fallen into disuse since the Evidence Act of 1898, but the underlying principle survives, and it may be applicable to situations which arise before apprehension and charge. Just to indicate to your Lordships that, at least at that stage in the development of the law of Scotland, the Lords will see it was recognised at that time it was not the function of the police when investigating a crime to direct their endeavours to obtaining a confession.
I think the Lord Justice General's remarks were regarded at the time as wildly out of date, actually. There was a lot of criticism of him for this.
Yes, my Lord, but it's simple to say, Lord, that in part, that what the context your Lordships are concerned with was recognised, at least at that time, the law of Scotland. And the decision of Chalmers, Lord, as I understand, it's not been substantially departed from since.
But surely the whole point of sections 15 and 14 and 15 was to change this.
Exactly.
Yeah.
Well, I recognise, my Lord, that was designed to develop the position so that police officers...
I mean, the idea that you're making spontaneous statements, I imagine these interviews, I mean, look at the present one, very structured and lengthy.
Yes, Lord, but there are observations that are part of the law of Scotland and Chalmers, in my respectful submission, Lord, which recognise at least that before the 1980 Act, it was recognised that the police's primary duty was investigation rather than endeavouring to obtain confessions. Now, the point I sought to make very briefly to my Lords the other day is that the practice since 1980 has developed so that, as I think is effectively expressly accepted by the Lord Advocate, the police have used that increasingly as an investigative device to obtain admissions against interest, which form a significant part of modern approach to prosecution.
Sorry, I'm interrupting. It's quite a useful passage at pages 81 and 82.
Yes.
The Lord Justice Clerk really making the point that the police have quite a difficult task, or at least they did, because once, as he puts it at page 82, once the stage of suspicion is reached, then the suspect in this position that thereafter the only evidence admissible against him is his own voluntary statement. So questioning can't go on after that point, and it was always very difficult to work out exactly when that stage had been reached. And one of the points, as I understood it, of Section 14 was to allow that to be done, because, I mean, the person is being detained on reasonable suspicion.
Yes, absolutely, Lord. I accept that. I think it's the point Lord Roger made earlier today, that once the point of suspicion is reached, there are grounds for detention, subject to the other conditions being met, Section 14. It's also to illustrate, Lords, that at least, as I think the Lord Justice General points out, the principles he was articulating had been part of the law of Scotland for 80 or 90 years before Chalmers, and at least at that stage, and until the process that your Lordships are presently concerned with was introduced in 1980, in very large measure, investigations proceeded without this advantage from the prosecutor's point of view of questions being asked and answers given very often against interest. And of course, as my Lords will appreciate, it's recognised in the European court case law that includes what I think would be described in British terms as mixed statements, so that the reach of the guarantee extends to statements made which may not be directly incriminating.
Sorry, if during this section 14, 15 interview you make an incriminating admission, I mean, at what point do you have to be then charged and therefore an end put to the questioning?
Well, Lord, the natural end point is the expiry of the 6 hours.
But that's it. I mean, you can go on questioning even though he's long since ceased to be a suspect. I mean, he's now plainly the man you want. You can still go on questioning up for 6 hours.
Yes, you can. And indeed, that's my point, really, my lords, in the practical development of the use of this process is that's a very common feature of modern investigation.
I think there was a time when it was being argued or suggested or was in the air that the kind of thing Lord Bryan was talking about, that there would come a point when there became a duty to charge and arrest and charge and so on. But I don't think that has ever been actually held.
I mean, I think that's how we do it, isn't it? This side
maybe
of the
wrong.
border. Yes, I mean, you can arrest, question, arrest on reasonable suspicion, question, but as soon as that turns into whatever it is.
Well, once you have sufficient information to charge, you're obliged to charge.
Yes, and then you can't ask him anything else.
You can't ask him.
I may be wrong, but I don't think that has ever been held in Scotland. I may be wrong.
No, I think the Lord is right. In Scotland, that doesn't...
Well, there's nothing actually on the wording of sections 14 or 15 to stop the process going on throughout the entire 6 hours, as far as I can see.
That's absolutely correct. And that's the practice.
I have a sort of feeling that there was, though, an argument. Is it a case Tong or something like that?
Yes, absolutely, Lord. Yeah. I think the case of Tong is one that the Lord Advocate refers to as in the course of her printed case, Lord. It's part of the argument about safeguards. Lord, I wish to say just something very briefly about that, if I may, just on the one particular matter. Obviously, the general thrust of the appellant's submission to your lordships is that the safeguards identified in the Lord Advocate's printed case and her submissions to your lordships do not answer the criticism which is levelled in the wake of the decision in Saldos. The possible exception to that, Lords, is the administration of a caution. I sought to draw your lordship's attention to what the European Court had said about the possible dubious efficacy of a caution in any event. But if I could just complete the matter, my lords, very briefly, if I may, by reference to one additional case which there should be copies of available for your lordships. It's the case of Pennycook against Lees. Yeah. I understand that they were handed up at the beginning of the hearing, my lords. I hope it's immediately available.
Pennycook?
Pennycook, my lord, thank you. It's 1992 Scottish Criminal Case Reports, page 160. My lords, this was a case where my lords will see the appellant was charged with making false claims for the purpose of obtaining social security benefits. He made certain false statements.
Yes,
it was me, I see.
My lord and the chair delivered the opinion of the court. My lord Roger was the Solicitor General at the time. So it's maybe a trip down memory lane for your lordships. But in any event, the court...
Oh, it is, yes, I recognise that.
Have you got another copy of this case?
You've got two copies.
Yes, I do.
I think they're coming round, don't they?
Oh, they're coming around. Sorry. Excellent. Right.
This is tricky.
Thank you.
I remember this case.
I do, too. This was tricky for the Crown.
Yes. I'm not sure this is a very good decision.
No, I wasn't pretty sure. I think neither of us is quite sure this was our finest hour, but never mind.
Well, Lord, it's certainly a lasting monument to your lordship's submission, which is my point for this afternoon. The Lord is, on this matter, the Lord and the Chair, giving the opinion of the Court, as I understand it, very short report, recognised that even in circumstances where a caution has not been administered, the question of whether the evidence is admissible is subordinated to a general question of fairness. And I think the Lord indicates that at page 164 of this report. I regret that these are not paragraphed. But
is it page 5 of 6, is it? Or which?
It's page 5 of 6, my lords, in the print.
Yeah.
My lords look down to the fourth paragraph. As the argument proceeded, however, it appeared that the test which Mr McBride was inviting us to apply was that of fairness in all the circumstances of the case, the question whether the appellant was or was not a suspected person being one of the circumstances to be taken into account. It was to this test that the learned Solicitor General addressed his argument in reply, and in our opinion he was well founded in this approach. So, without, I think, taking up too much time, we'll also see that the nature of the argument was subordinated to the general test of fairness, which had been earlier articulated by the court. So, I simply respectfully make the point, Lords, that with the benefit of the passage of time and the decision your Lordships are presently contemplating from Saldus, the one possible safeguard to which the Lord Advocate could legitimately refer in my submission in the context of this argument is, by virtue of that decision, which has been followed, as I understand it since, a rather less of a safeguard than might first appear.
Sorry. So this is put forward the proposition that a caution is less of a safeguard than might at first blush appear, is that it?
That's it, Lord, thank you.
So it's not an absolute requirement of admissibility.
No, Lord.
That's the point.
Precisely, Lord. And that's to be seen, Lord, in light of what the European Court has itself said about caution, to which I drew your Lordship's attention. If I could just remind my Lords, in that context, it was particularly from the decision in Peshalnikov against Russia, which, if I could just remind my Lords, was Volume 6, tab 138.
Yes.
This was perhaps helpful, Lords, because it deals in successive paragraphs in the report. Page 23 is paragraphs 78 to 79 of the associated issues of waiver and caution.
Paragraph
78 and 79. If I could just remind the Lords of that. I think I drew attention to this earlier.
Yes, you did.
Yes.
Yes, sir. Yes.
78, of course, deals with waiver in the particular context your Lordships are most immediately concerned with. That is to say, the right to counsel, as it's described at paragraph 78. And the Lords will see that the Court articulates the principles to be applied if there is to be waiver in that context. And the Lords will see that the Court said that the right to counsel being a fundamental right amongst those which constitute the notion of fair trial and ensuring the effectiveness of the rest of the foreseen guarantees of Article 6 of the Convention is a prime example of those rights which require the special protection of the knowing and intelligent waiver standard. It's not to be ruled out that after initially being advised of his rights, an accused may himself validly waive his rights and respond to interrogation. However, the Court strongly indicates that additional safeguards are necessary when the accused asks for counsel, because if an accused has no lawyer, he has less chance of being informed of his rights, and as a consequence, there's less chance that they will be respected. And of course, correspondingly, in the practical field of waiver, Lords, the less likelihood there is that there can be a knowing and intelligent waiver of that particular, obviously of the right to silence, by analogy, because without a lawyer present, Lord, the advice can't be obtained in the first place to give rise to a knowing and intelligent waiver. And although the Lords are primarily concerned with the right of access to a lawyer in this context, it is, of course, the submission for the appellant. The principal significance of that in this case is to help respect the right to silence or the right against self-incrimination. And my Lords will also see paragraph 79, I think I mentioned this to your Lordships earlier, that there's reference to the observations of the Court about the caution and not being necessarily a particularly robust safeguard in the context.
Yes.
But just help me with this business of statement facts and issues, paragraph 4.
Yes.
I mean, your client was told he was entitled to have information of his detention sent to a solicitor, and he declined to have a solicitor contacted.
Yes.
I mean, I suppose in England he would have been asked, would you like to consult a solicitor?
Yes.
I mean, it seems to me that inevitably he would have answered no. I mean, if he doesn't want to have a solicitor notified of his detention, he doesn't want to consult him. Well, why would we suppose that he would have actually done other than he did if the Scottish law had been the same as English law?
Well, my Lord, it's precisely that makes a difference.
What is the difference?
All that he's entitled to have, my Lord, as the law is presently understood, is intimation sent to a solicitor.
But he doesn't know that if he in fact answered that question, yes, I would like to have a solicitor notified, and then gone on saying, what's more, I'd like to consult him. He hasn't the faintest idea. At least one doesn't suppose he has. That actually he'd have been told, or might have been told, terribly sorry, you can't.
Well, my Lord, the case law, first of all, in relation to waiver, because I appreciate this is a point my Lord has raised, the case law in relation to waiver, in my respectful submission, particularly in relation to Bishalnikov, indicates what is required for it to be waiver. And this case doesn't remotely, in my submission, come close to that, because there isn't even the starting point my Lord identifies would be appropriate in England and Wales, but that is to say, the requirement on the police as agents of the state to indicate that the suspect has the right to legal advice before he's interrogated. Lord,
And as my Lord Mance pointed out, he must also be told that questioning can be delayed until the solicitor arrives.
Absolutely, Lord. So there's in my respectful submission, Lord, there's a world of a difference between the very narrow right under the Criminal Procedure Scotland Act to have intimation sent to a solicitor, and the essence of the matter your Lordships have drawn attention to today under PACE, and that opens up entirely different questions, Lord. But I noticed that in answer to the point my Lord earlier raised, I don't detect either the Lord Advocate or my learned friend Mr Summers to be suggesting to your Lordships there is waiver in this case. And in my respectful submission, insofar as they are not making that submission, they're right to do so. And for reasons which I think underlay my Lord's earlier question, then if they do not do so, their argument fails in my submission. In other words, as my Lord raised earlier, one has to go that far from their point of view in my submission, because the context in Scotland is a system which does not permit access. So the answer to that, in my respectful submission, has to lie in waiver alone. Well, so I think I drew that your Lordship's attention to it in the appellant's printed case, but I do rely on Bishalnikov and the approach that the European Court suggests is appropriate in this context for waiver, because it's a high standard and it's important for the reasons my Lords have been teasing out, my learned friends. But it is not said against me that there has been waiver, my Lords, in my respectful submission. It couldn't be said that there has been. Lords, against that background, Lords, in my respectful submission, your Lordships should be satisfied that the reasoning of Saldus is applicable to this case. My primary submission to your Lordships was that insofar as any kind of practical prejudice is involved at all to instruct the conclusion that there's been a violation of the right to a fair trial, again, your Lordships are given guidance in Saldus, and that is just simply to look to the fact that the evidence was used for conviction. But if I were wrong in that respect, my Lords, looking at the points I think my Lord Mance raised earlier on, then in this case, my Lords would simply look to see, in practical terms, what significance can reasonably be attached to the admissions which were made in this case by the prosecutor conducting the trial. And pausing for a moment, Lords, if the argument in a conventional appeal against conviction had been that the evidence of the admissions ought to have been declared inadmissible and that the judge at first instance erred in that respect, then the simple answer in the appeal against conviction would be to invite the appeal court to look at the potential significance of the replies in the context of the evidence as a whole. And by that analogy, my Lords, the appellant, in my respectful submission, would succeed before your Lordships, regardless of the primary submission which I've sought to advance to my Lords earlier. So I respectfully seek to clarify that insofar as my Lords are not persuaded of the primary position. Yeah. Lords, the Lord Advocate addressed with your Lordships earlier today issue 5, which was whether section 57.3 of the Scotland Act avails her position in this particular instance. Lord, so far as that is concerned, in the printed case for the appellant, Lords, I draw attention, as I think your Lordships have noticed. This is page 19, Lord. I think Lord Roger drew attention to this in the discussion with the Lord Advocate this morning. Perhaps I could briefly remind my Lords of that. Lords, I draw attention to section 14, subsection 7a, and it's set out there for my Lord's benefit of paragraph 5.3. And that, of course, refers to what your Lordships were discussing earlier without prejudice to any rule of law. So it's, in my submission, instructive to remind your Lordships that section 14 confers a right upon police officers to question, but without prejudice to the use to which that material may be subsequently put in a prosecution. And for reasons, my Lord, which I've sought to set out in the printed case, I say that is significant. The legislation, relevant legislation, Lords, is reproduced on the following page for my Lords. That is section 57 and section 6 of the Human Rights Act. The Lord Advocate's case on this point depends on the application of section 6(2)b of the Human Rights Act. And as your Lordships were putting to the Lord Advocate earlier, since this is a piece of primary legislation, the first question is whether it can be read compatibly in terms of section 3 of the Human Rights Act, should that arise. Now, it seems to be accepted, Lords, by all parties that the proper approach to this section is, as my Lord and the Chair described it in his speech in the case of Hooper, which I draw attention, Lords, at paragraph 5.8, in particular what my Lord had to say at paragraph 73 of Hooper. Lords, Hooper is to be found in volume 3, tab 48.
Is there anything more, actually, than that we get in your print?
That's really what I wish to refer to.
Do we need to fish out the bundle to find it?
I'm obliged, my Lord. Really, to save my Lord's the particular difficulty, I've referred to what my Lord says at paragraph 73 about the proper approach.
Yes.
And there doesn't seem to be any contention before the court that that is the way to approach the matter. And so, against that background, Lord, I contend before your Lordships that in order to succeed on this issue, the Lord Advocate would need to establish the two propositions which I respectfully set out for your Lordships in the printed case. That is to say that the legislation cannot be read or given effect to in a way which is compatible with conventional rights, and that in any event, relying on the impugned evidence, the Lord Advocate was acting so as to give effect to or enforce those provisions. Now, my Lords will be very familiar with the observations made by the House of Lords and Guyton on the nature and strength of the interpretive obligation. In my submission, Lord, as I say at paragraph 5.12, there is, in my submission, no reason why the Lordship should not read it, as I suggest it can be read in paragraph 5.12, applying section 3, if necessary, to that exercise.
You really come to the key point in paragraph 5.16 of your case, don't you?
Yes, absolutely, Lord. In my respectful submission, that is essential. There's no express provision to the effect that the answers given may be admissible in evidence in any subsequent prosecution. And on the contrary, it's expressed as being without prejudice to any relevant rule of law. And that, I think, brings me, my Lords, to the points my Lords were raising with the Lord Advocate earlier today. Lords, trying to listen carefully to what your Lordships were asking. Lord, on the one hand, the European Court doesn't concern itself with the questions of admissibility of evidence, which I think is the point Lord Mance mentioned. However, on the same approach, my Lord and the Chair and my Lord Roger were drawing attention to the fact that in practical terms, if the interpretation of Saldus contended for at present is correct, then it could sensibly and in practical terms in Scotland devolve into a question of admissibility of evidence. That is not to say, my Lords, that the European Court is in any way departing from its general approach. of saying that questions of admissibility are the matter of the National Court. It's just taking the principles in my submission from Saldus and casting them into a domestic context would suggest that the appropriate approach might be to seek to exclude the evidence as inadmissible, if indeed there were a rule of law of the kind your lordships were contemplating earlier with the Lord Advocate. So in my respectful submission, there is no discontinuity between the observation Lord Mance made and those that my Lord in the Chair and Lord Roger made. In fact, it's just respecting the role on the one hand of the European Court and on the other the role of the National Court, including your lordships, in giving effect to the Convention principles in a domestic setting. Well, if I were wrong about that, the other way to look at the matter, in my respectful submission, is by brief analogy to what your lordships had said in the Judicial Committee of the Privy Council in the case of Holland, which was the court simply looked to the fact that the impugned evidence, in that case doc identification, had been introduced and relied upon by the prosecutor as one element of his case. And your lordship simply looked at the matter in the round, recognising that that had been introduced, and asked the question of whether that piece of evidence in the context had imperilled the fairness of the trial.
What is the impact of Hoop? My Lord is dealing with a situation where there's discretion. I can see that if there is a discretion given by the statute, which, if exercised, will always lead to a breach of the Convention, because its exercise is inevitably contrary to the Convention, then you would be undermining the statutory discretion if you said, in order to comply with the Convention, the public authority must refrain from exercising its discretion.
Yeah.
But supposing you have a discretion, and it's an open discretion, if you exercised it in certain ways, on the face permitted by the statute, there would be a breach. If you refrained, if you did in other cases, there wouldn't be a breach. Then surely you're in a different ballgame, aren't you? And on one view, I mean, depending how much weight you give to the words as a general rule, on one view you might be in that ballgame here. I suspect it would be difficult because the European Court has said as a general rule and seems to be laying down a prima facie position. But what is the position?
Well, Lord, my respectful submission, really, for reasons I set out in the printed cases, that the Lord Advocate cannot, properly speaking, submit to your lordships that she was acting so as to give effect to section 14(7), because, Lord, I see that there's a helpful contrast to be drawn with the situation that the House of Lords was concerned with in Council, and particularly what my Lord and the Chair was considering there. As my Lords, I think, saw earlier, the provision of the Insolvency Act under consideration there, section 433, was concerned with the permitting of the use of evidence. It had no other function, Lords. That's was. So in my respectful submission, I say that even if I were wrong, Lord, on the first point, that the legislation couldn't be construed compatibly, in any event, I say that the Lord Advocate is not acting so as to give effect to the provisions of section 14, because the provision of section 14 permits the police, in my submission, Lord, to ask questions.
Yes, the discretion is given to the police officer to put the questions.
Yes.
But the question of whether the Lord Advocate can use the answers will depend on the rules of law about admissibility. And you're saying, well, build in the Saldus principle that, in effect, is telling you that the answers given in an interview where there's no solicitor present are inadmissible.
Yes.
And therefore, the Lord Advocate is trapped, actually, by the very wording of Section 14, subsection 7 itself.
Yes.
It's not. I mean, your proposition doesn't really depend on the Hooper analysis about the exercise of discretion. I would have thought, at the stage at which one's considering whether the use of the evidence by the prosecutor is permissible.
Absolutely not.
And unlike Cancel, there's nothing in the actual. It isn't actually talking about the use of the evidence by the prosecutor, except insofar as the prosecutor is bound to by the rules of law about admissibility.
Yes, indeed. Even though the provision I think the Lord had under consideration in the Insolvency Act was designed to say that the evidence could be used expressly. So in my submission, there's a helpful analogy there in favour of the appellant's position.
Then there's, I mean, it really means that he must always exercise, or she must always exercise the discretion so as not to use the evidence.
Yeah.
Doesn't that rather undermine the points of sections 14 and 15?
No, my Lord, in my respectful submission, it doesn't, because section 14.7 does not provide the Lord Advocate with a discretion.
That's your fundamental, if I may say so, anterior position.
Yes.
Without referring to the rubric relevant rule of law at all. I mean, even if that argument drops out, your pointing is she's not fulfilling section 14 and 15 because it's got nothing to do with her on the face of the legislation. There may be a consequence of the use by the police of section 14, but it can't be said that she is, what's the expression?
Giving effect
to the legislation.
Yes, indeed, Lord, in my respectful submission. And the Lord Advocate perils her submission to your Lordships on the basis that the public authority in question is my learned friend, rather than any other.
There's nothing in this case equivalent to section 433 of the Insolvency Act in Council.
No, there is not.
Supposing there had been, what would be the position then? Supposing the statute had said, and any statements made in the course of the interview may be adduced before the court, and there'd be no qualification, such as we know there is, subject to the rule of law.
Well, I recognise, my Lord, the position would then be much closer to the situation that was present in Council.
Yeah.
I recognise that, Lord. So it very much depends in my submission on the circumstances, assuming, of course, that the court couldn't come to a compatible reading of the Convention on the first proposition. And in my submission, obviously, for reasons I've sought to set out in writing, the court can and should, if necessary, do so.
Does Saldus prevent the police making use of information that they obtained for their own further inquiries? I mean, the qualification is about the admissibility in evidence of any answer given. In your case, of course, is directly under that umbrella. But the police may question and get information which may lead to other people, or it may actually lead to the obtaining of other evidence, which, quite independently of the answers, may be used to support a case against the detainee. You don't have to take the case as far as that, but I just wonder whether Saldus is cutting that off as well.
Well, Lord, in my submission, I don't, in answer to my Lord's question respectfully, I don't need to travel that distance in the first instance, and secondly, Lord, it's not part of my submission in any event that that is what the decision
We
suggests.
saw a glimpse of that nightmare scenario in the Dutch case, I think.
Yeah.
Yes.
I mean, that's very serious too. I mean, it just...
That was their particular take on it.
Yeah. And it's the classic thing of just saying, well, I can tell you where the body is, and you don't use the answer, but you find the body and you link the person by the DNA on the body to the clothing which the chap has on him when he's detained.
Well, I'm very conscious of the difficulty, my Lord, but my submission doesn't extend that far, if that answers my Lord's question. Lord, so I'd respectfully invite the Lords to the view that section 57.3 does not avail the Lord Advocate in this particular instance, and in doing so, Lord, I've drawn attention to what my Lord Rogers said, that the language of section 3 contains two distinct obligations, my Lord, and I make an additional point about that, which I don't respectfully orally repeat to your Lordships. It may be perfectly sufficient for present purposes as the discussions develop to rely on what I've said to your Lordship. And I invite the Lords to the view that that is an issue should be resolved in the appellant's favour. Lords, that leaves, in particular, Lord, issue 8, which I think it's fair to say, Lords, is a very substantial matter indeed, and I'm very conscious of the time, Lord. Perhaps I could say one or two things to your Lordships about the matter, yes, at least in outline, because of its importance. Lord, of course, the appellant's primary position is no temporal question arises in this appeal. While it might arise in other cases, it doesn't arise here. The decision of Saldus was given, as my Lords know, in November 2008. The relevant proceedings in the interview and trial in this case came after the decision, so the appellant's primary position is no such issue arises. Now, my Lords, I also make certain points about the European Court of Human Rights approach to its own case law, my Lords, which I've set out in the printed case. Lord, I make certain points about the European Court of Human Rights' own approach to the case law, which I've set out in writing. I appreciate your lordships have had the chance to see that, and I don't wish to repeat that more, but it's plain from those cases that the European Court, Lord Advocate referred to Marx, and that was plain example of the court seeking to limit the temporal effect of its own decision. And I make reference to Mikolev against Malta, and make certain submissions in writing to your lordships about that. And very shortly, put, Lords, standing the time, I invite Lords to take the view that the European Court in the Grand Chamber did not consider it was departing from its previous case law, because if it had, Lords, again crudely put, it would have said so, and it hasn't. And the reason it hasn't, in my submission, Lords, is because, as my learned friend Mr Summers was at pains to draw to your lordship's attention, today the principles in Saldus really all build upon the principles that have been articulated in previous cases, none of which the court said it was departing from. Now, my Lords, the Lord Advocate raised with your lordships the very important issue of prospective overruling. My Lords, it's fair to say that, at least in Scotland, as regards the criminal law, that has not been the approach. I make reference to that, Lords, under reference to the Lord Advocate's reference number 1 of 2001. Lords, I've set out the passage from the opinion of Lord McCluskey in the printed case at page 31 and following. I don't think I need to read that to my Lords, but it is an application of the declaratory theory of the law. Lords, as I understand your lordship, the decision of the House of Lords on In Re Spectrum Plus, which was mentioned earlier, and I refer to it, page 33 of the printed case, Lords, the position was that your lordships were asked to consider, sitting in the House of Lords, whether prospective overruling might form part of the common law of the United Kingdom. I understand, again, with no disrespect to your lordships, that the essence of the decision was that your lordships said it would be unwise to say that that would never be the position, but that this is not the case for it. Now, Lords, of course, I also submit to your lordships that on any view this is not the case for it, because this is a criminal case apart from anything else, and that raises in my submission very important considerations of practice and principle, and as my Lords will have seen from the printed case, I seek to draw in that regard substantially on the speech of Lord Nicholas of Birkenhead in the case of Ray Spectrum Plus. Lords, I draw attention, if I may, to part of Lord Nicholas' observations at page 33 and 34 of my printed case, Lords, in relation to what effect pure prospective overruling would have in a criminal case.
Well, if it's pure prospective overruling, then your client wouldn't get the benefit of the argument you've been presenting at all.
Absolutely right, Lord.
And I see the grounds for your objecting to that.
Yes, indeed, Lord. That's the Crown's primary position in the written case was that the present appellant ought not to get the benefit of any favourable decision, because your lordships should go so far as to depart from the position the United Kingdom's courts have so far adopted, and A, adopt prospective overruling at all, and B, do so in its purest form. Thus, as Lord Nicholas points out, leaving a successful defendant languishing in prison in paragraphs 26 and 27. Now that's, Lords, the general background of the position. It might be...
Sorry, what actually happens to your client's case if you're right on all this? We do what we send, what do we do?
Well, Lord, I was going to come to the technical aspect of that, Lord. Because your lordships are seeking, on the invitation of the appellant, to resolve a devolution issue, your lordships would, in my submission, if the appellant's argument were well-founded, be concluding that in leading the evidence in question and seeking a conviction, the Lord Advocate was acting incompatibly with the relevant convention rights of the appellant, and accordingly ultra vires. And the consequence of that, Lord, as your lordships, at least in the Judicial Committee, the Privy Council pointed out, is to reach the conclusion that there having been an ultra vires act, there can be no convictions.
Well, what has happened here, if I can remind myself, is that your client actually went to trial, was found guilty, a community service order was imposed, it was a £500 fine,
Yes.
Compensation.
Compensation order, and there was an attempt to raise this devolution issue, which was dealt with administratively in the appeal court. So it's never been actually heard as an appeal against conviction. What are we to do? Are we to simply dispose of the thing here or send it back to the appeal court?
Well, Lord, as I earlier indicated, Lord, both courses have been followed in the past by Judicial Committee of the Privy Council. Lord, my invitation to your Lordship...
Which Privy Council case are you talking about?
Holland and Sinclair, Lord.
Holland, okay.
Yes.
They were examples of the board quashing the conviction, Lord,
Yes,
exercising the powers.
That was a situation where the court below had an opportunity to consider it. Here they haven't.
Yeah.
Well, I appreciate that, Lord. It's an unusual situation because leave to appeal was refused.
I think relations are bad enough without us perhaps exacerbating them by actually deciding an appeal which they hadn't actually had an opportunity to look at.
There's a logical leap, isn't there, in the submission you made a second ago, that just because the Lord Advocate is seeking to adduce inadmissible evidence and obtain a conviction, therefore the conviction must be set aside. I mean, it might be a very, very minor piece of evidence. He would be acting ultra vires in relation to that piece of evidence. Everything else would be valid.
Absolutely.
And the conviction might well stand.
I was seeking, my Lord, only to focus attention on the, technically speaking, on the invitation of the prosecutor.
Well, that's what you're advising, but there is a huge question which has to be decided.
I recognise there's a question there, my Lord, but the way it's been analysed historically, as I understand it, is to say if the Lord Advocate seeks a conviction, that's the focus of the against a background of a breach of the right to a fair trial.
That was all said originally in cases where the delay was the point, and that point has all been resolved. And as Lord Mann says, we're relating to one particular item of evidence. And the question would then be, what's the effect on the whole thing? And
if I could ask my Lords to look at it in more conventional terms for a moment, then, since this is in substance an appeal against conviction, Lords, the contention before your Lordships is that whichever precise interpretation your Lordships put on the case of Saldus, the result should be the quashing of the convictions in this case because it instructs the conclusion that the trial overall was unfair.
Well, we haven't been asked to study the transcript of the evidence or the effect of the sheriff's charge and all the rest of it. So, really, one would have to go through, in fairness to the prosecutor, the material that was before the court to see whether, extracting the inadmissible evidence, the result would be that the conviction should be set aside. And that really is a task for the appeal court, isn't it? And even if they did reach that position, then they would have to decide what to do. I mean, I don't know whether the community service order has been served or the compensation order paid. Do you know?
I can ascertain that, Lord, in a moment. Lord, while that's being ascertained, Lord, perhaps I could say in recognition of the observations your Lordships are presently making, well, I recognise it would be open to your Lordships to give guidance on the matter, and this might be a relatively unusual case where your Lordships don't move to giving effect to the final invitation of the appellant to the court, that is to say, to quash the convictions, in recognition of the practical, procedural matters that both Lord Chair and Lord Roger referred to.
You accept that would be an unusual disposal? Speaking for myself, where there is an evaluation of evidence to be undertaken, as a matter of general principle, one would have thought that the High Court of Justiciary is where that exercise should take place.
Yes.
Well, I see the force of that, Lord. It's certainly, Lord, not part of my function, to borrow Lord Roger's words, to ask my Lords to take a step which would make matters more difficult.
And they would follow the guidelines, presumably, in McGuinness, would they?
we'd hope so, Henry.
One would hope so.
Well, I was going to say there might be a question about that, Lord, but since Lord Rogers made that observation, perhaps there won't be. But in any event, Lords, I recognise that we're open to your Lordships to take that course, and that would leave the matter to be dealt with. It is procedurally unusual because there was no hearing, as my Lord pointed out, in the High Court on the merits of the matter at all, since leave to appeal was refused. Lords, looking, if I could, briefly, Lords, at some of the practical issues about the...
I don't know whether you've had an answer to the question.
I'm sorry, Lord. The answer is I'll need to, Lord, have that clarified. I'm afraid I can't immediately answer Lord's questions to whether the order has been completed or the fine paid.
So you could let us know
yes,
in correspondence.
It's not uncommon either for these matters to be suspended pending an appeal, as your Lordships will appreciate, or sometimes informally suspended in effect without formal suspension, simply not put into operation, Lord, because there is an appeal pending.
Yes. Well, certainly you did take steps to bring the matter before the court, so I don't think you can be blamed for the fact that the court refused to handle it.
No. So I'll perhaps need to have that confirmed by those instructing me, Lord, after the hearing.
Yeah.
Lord, so if I could ask my Lords just to consider briefly some of the practical aspects of the matter, because the Lord Advocate has understandably raised with your Lordships the fact that a particular outcome might have significant consequences for the system. Lords, perhaps I could, in light of what the Lord Advocate submitted to your Lordships about the United States Supreme Court in the case of Griffith, which seemed to be particularly concerned with classes of cases, perhaps the Lord Advocate's most practical concern, Lords, are those cases which are finished in Scottish terms. And therefore, perhaps I could just say to my Lords two things about that in terms of the route by which these cases might come back before the appeal court, because for very obvious reasons, my Lords, only the appeal court at that level could in the first instance consider granting an effective remedy. So the two, my Lords, very broadly are, of course, one, and a person convicted may seek leave to appeal out of time, Lords, under the 1995 Act.
Do you have a section in mind?
112, isn't it? Yes, no, it's... Lord, if your Lordship would just allow me a moment. 111. Lords, it's 111 of the 1995 Act.
Yes.
I mean, why should this be different from, say, all the people who were convicted on one particular view of the law of corroboration in rape, for example?
Well, of course, my contention, Lord, is it shouldn't.
Oh.
In other words, on that view, Lord, or in the view that the Lord expressed on behalf of the court in the case of Galbraith involving diminished responsibility, the principles that the High Court was applying, Lord, were the declaratory theory, so the court explained the law as it's always been. As a consequence of that, from time to time, Lord, when that occurs in Scotland, in the modern period, people have come forward and sought leave to appeal out of time. Now, Lords, I don't wish to trespass on the situation as it pertains in England and Wales, but I do understand in a general sense that the Court of Appeal Criminal Division has a policy, broadly speaking, in relation to that kind of application based on what is sometimes described as a change of law. And
that's not a facility available if you've already appealed, is it? Or is it?
It is not, Lord.
No.
It is
you
not.
You then have to depend on the CCRC.
That is absolutely correct, Lord. And that is the other recognised route for proceeding, if there's already been an appeal. Now, Lord, something was said about the possible impact upon the Commission and others. Perhaps I should, my Lord, in the context of the present case, just indicate to your Lordships that I'm presently a member of the Scottish Criminal Cases Review Commission.
What? You're president of what?
A member of the Scottish Criminal Cases Review Commission, Lord. So, for that reason, it might be that my Lords would forgive me for not wishing to comment on any question of policy that might be being presently under consideration in relation to this issue, but plainly, like other aspects of the criminal justice system, there may be some practical consequence. It is now, however, perhaps, my Lords, worthy of saying that one of the reasons, in my respectful submission, that the High Court of Justiciary has not developed a policy comparable to that of the Court of Appeal Criminal Division in England is because it has never, in reality, been faced with a flood of cases whenever there's a convulsion in the law. And the example of Galbraith is one. The development of the law of rape certainly did produce a number of appeals, my Lords, but relatively speaking, a very small number. Perhaps the most obvious example in modern times, my Lord, is the decision of the High Court in Stars and Ruxton in respect of temporary sheriffs. Now, my Lords will appreciate, I'm sure, from the recollection that, relatively speaking, of the numbers of convictions and sentences which were open to challenge as a result of that decision, a very small number were actually challenged. So there is no convincing evidence at all in Scotland, Lords, that any of this unexpected wave of cases has come to the fore in any of these particular situations. And in any event, Lords, the Crown deployed, in the context of temporary sheriffs, two devices, both of which were in a sense, outstandingly successful from their vantage point of view. The first was waiver, which took, until the case was decided, Miller and Dixon before the Judicial Committee of the Privy Council to be exposed as incorrect, by which time the Crown had stemmed some of the cases being brought before the appeal court. And having lost that argument before the board, the Crown then resorted to relying on acquiescence, which was also outstandingly successful because, as my Lord Roger alluded to earlier, when his Lordship gave the leading opinion in the decision of Robertson, the board accepted that one could acquiesce in an ultra vires act of this character by the Lord Advocate. So there are recognised mechanisms in Scotland, Lord, both before and after the event, in the form of waiver and acquiescence for checking the flood of cases. And the reality of the matter is, as I think the Lord Advocate was alluding to, is that were the High Court Justiciary to be faced with a flood of cases, it would be perhaps surprising, Lords, if the court, under some prompting from the Crown, didn't seek to develop a policy comparable to that which apparently operates in the Court of Appeal Criminal Division in England and Wales. So it's just to make it clear, my Lords, that first of all, recent history doesn't suggest, despite the importance of the decision, that there will necessarily be a flood of cases. It depends. And the second thing is, Lord, there already are mechanisms in place for dealing with the matter of one kind or another. So in my respectful submission, at least to that extent, your Lordships should not be necessarily persuaded that the system will be significantly disturbed by a decision which is favourable to the appellant. In other words, Lords, time will tell. What your Lordships are being invited to do, in my respectful submission, is take a very significant step indeed, which is to adopt a doctrine of prospective overruling in the face of a practical threat, the scale of which is no doubt difficult to anticipate, but history suggests will not be as grave as was being suggested earlier. There have been, as I understand it, 1,500 or so devolution minutes raising the issue, Lords, but that doesn't, today at least, inform your Lordships as to the true extent of the matter, because of course many of those points have been raised pre-trial. What has been happening since the decision at Maclean, Lords, is two things in practice. When the minute has been raised pre-trial, Lord, it's simply been dismissed by the presiding judge on the authority of Maclean, and that is entitled on the face of it the accused person to preserve his or her right of appeal against conviction in the event that they are convicted, of course, and secondly, that your Lordships produce a favourable decision so far as the present appellant is concerned. So that is the practice at first instance, Lord. So far as the appeal court is concerned, as this case demonstrates, Lord, those who have sought leave to appeal have been refused it on the authority of the decision of Maclean. So those are also practical parameters, Lord, because those who have so far sought leave, unlike the present appellant, and been refused it by the High Court, if it's a solemn case, may have considerable difficulty ventilating any appeal against conviction unless they are in a position to persuade the Commission to refer their case. The principle of finality and certainty, Lord, which lie at the heart of the Lord Advocate's contention for your Lordships uprooting the system which is so far applied in Scotland. The High Court said in the case of Cooper recently, principles of finality and certainty did not form part of the Court's analysis of a miscarriage of justice, but rather those were matters in older cases, at least for the Scottish Criminal Cases Review Commission, to keep under consideration in relation to the second statutory test which the Commission has to address before a case is referred. That is to say, whether it's in the interest of justice to refer a case. So that there are various mechanisms not already in place in my respectful submission to ensure that the practical consequences of any positive decision so far as this appellant is concerned are limited in their application. And that, Lords, I think brings me, if I may, just to mention to your Lordships the recent decision of this Court in the case of Ahmed. And I think the Lord Roger alluded to that earlier. And there, as I understand it...
Oh, yes, sorry. Yes, of course.
Yes, indeed.
Yes, we refer to it initially by initials and remove the anonymity. And that's why it sounds familiar.
I'm sorry, Lord. It's the case in which one of the issues arose was whether your Lordship should suspend approach.
Where have we got it?
It's volume 2, my Lord, tab 27. 22, my Lord, I beg
222.
Lords, if I can ask my Lords to turn to this part of the judgment at page 463 of the report, in the judgment of Lord Phillips, with whom all members of the court, with the exception of my Lord and the Chair, concurred on this matter. The Lords will then see when judgment, it's recorded in paragraph 1, when judgment was given on the 27th of January this year, an issue arose in respect to the order that the court proposed to make. The court has held that the orders under consideration were ultra vires. This means that the restrictions imposed on individuals pursuant to these orders have been imposed without authority and are of no effect in law. Because this has not been appreciated, there has been compliance with these restrictions, not least by third parties, including banks holding funds of those purportedly affected by the orders. Thus, the orders have in practice achieved the effect that the Treasury intended when making them.
I think you can take as we know what it says. It's what bit are you going to refer us to, Mr. Shea?
I'm sorry, Lord. Perhaps then I should take my Lords on to the following page. First of all, at paragraph 6, it's recorded that Mr. Swift's submissions described in my Lord and the Chair's dissenting judgment, he did not suggest the court could or should give temporary validity to the unlawful provisions. He did not suggest that the court could or should purport prospectively to overrule them. He did not suggest the suspension was necessary in order to permit action by the executive, which might otherwise appear to be flouting the decision of the court. He did not suggest the suspension would have any effect in law. Mr. Swift urged that the court to suspend the operation of its judgment because of the effect that the suspension would have on the conduct of third parties. And that's the essence of the matter. And the Lords will say that the court concluded by saying at paragraph 8, the end sought by Mr. Swift might well be thought desirable, but I do not consider that they justify the means that he proposes. This court should not lend itself to a procedure that's designed to obfuscate the effect of its judgment. And accordingly, I would not suspend the operation of any part of the court's order. I appreciate my Lord and the Chair dissented, and his Lordship sets out his reasons for doing so.
You know what actually happened? You know?
I'm sorry?
What actually happened, I think, is this, that the judgment was circulated in advance so that parties could see what was coming, and the Treasury had time to put emergency legislation into effect before Parliament rose, I think, for the recess.
Absolutely, Lord. And I don't intend any disrespect to my Lord and the Chair at all, because his Lordship sets out his reasons for disagreeing with the majority view. But, Lord, insofar as it may be of some assistance to my Lords, of course the court was concerned with orders which had no legal effect or ultra vires.
Yes, I mean, you often have cases where government thinks it may lose something, and therefore, I presume it would apply to the Scottish Executive equally. They would make plans and dispositions to counter that possible outcome.
I think what did happen, and perhaps this would be of assistance to the Lord Advocate, it should be in your favour, Mr. Shedd. There was quite a problem to be considered by Lord Phillips and myself as to whether the Treasury officials should be allowed to see the judgment in advance, because under the practice directions, what happens is that the draft judgment is circulated to council on the Wednesday before judgment is given, or perhaps it's the Thursday, so that they can correct misprints or whatever else it would be. And that procedure would be followed in this case, that we would circulate the judgment in advance. But the question then would be whether the Lord Advocate, through her department, could do anything about it, whether she could communicate its contents to officials so that they could take remedial steps. And we need to check the records, but I think permission was given to the Treasury to pass the information to certain officials so that they knew what was happening and so that steps could be taken. So although, I mean, I can't see what is being referred to here, there's a certain amount of undercurrent in the case which one ought to be aware of. And
well, I'm grateful to your Lordship for that indication. Lord, I draw it to the Court's attention because the conclusion was that the orders were ultra vires, and there might be some analogy with the present situation as a consequence of that, because my Lords are resolving an issue under the Scotland Act,
yes,
which, if the appellant is correct, results in the conclusion that the Act, my learned friend the Lord Advocate, was ultra vires. That means that the orders were never of any effect, and that, in this context, means the invitation to convict was of no effect. And that's why I say that there might be some value in that analogy to the Lordships. Also points, in my respectful submission, very clearly away from interfering with the constitutional balance, Lord, and not introducing any notion of prospective overruling or indeed any question of suspension. Lord, on that last point, perhaps I should say, Lord, I'm confessed a little, if I may say so with great respect, surprised that my Lords are being informed in a general sense that any adverse decision might cause particular concern. The case of McLean, my Lords, which is the one which was argued in Scotland, of course, the argument began on the 1st of July before the appeal court last year, and obviously since the decision in Saldus and between then, there's obviously a possibility that the court will take a different view to that which has gone before, and it might, as the Lord Advocate indicates, necessitate legislative change of some description or another. So I simply say against that background, my Lord, it's perhaps just a little surprising that your Lordships have been asked today to suspend against that background, given the time that's elapsed since the Grand Chamber decision was produced.
Could you just help on that point of detail? You were in McLean, were you?
I was, Lord, yes. It was a reference case. It was heard, I think I'll be corrected by my friend Mr. Wolfe if I'm wrong, but I think on the 1st and 2nd of July last year, before a court of 3 judges.
The report just gives the date of the judgment, which was October.
The first hearing was before 3 judges on the 1st and 2nd of July of last year. The matter was then remitted on the invitation of the Advocate Deputy, my friend Mr. Wolfe, to a bench of 7 judges, and the hearing before 7 judges took place in October last year.
The hearing before 7 judges was in October?
October, Lord. And the court issued or indicated how it would answer the questions on the last day of the hearing in October, but didn't issue its extended reasons until December.
When it's headed up 22nd of October, that's not right?
Not in terms of the reasons, my Lord. The reasons were issued in December. 15th of December 2009 is my recollection.
So it says what it says is that on 22nd October the court answered the questions. That is correct.
That is correct.
And then it says the following opinion, but it didn't say the following opinion was later.
It wasn't issued until on around the 15th of December, my recollection.
Right. Thank you very much.
That's just to put the history into context, Your Lordships.
Yes.
Mr. McLean is appealing his conviction, Lords, contrary to the indication earlier. He's still seeking leave on that matter.
Yes. Well, thank you very much indeed, Mr. Shedd.
Thank you.
Lord Advocate?
I've nothing to add.
Sorry? Nothing to add. Well, the Lordships are very grateful to Council on all sides for their assistance, both orally and in writing. I said that we wouldn't give our decision on Friday of this week. I can be a little more precise and say that we expect to be able to give judgment on Wednesday, the 20th of October, but not before. So that gives you a timetable to which you can reasonably work. The court will now adjourn.